After the court's latest ruling, federal agencies may no longer interpret the law the way they used to. A decades-old principle just ended, and the shift is quiet, but structural. For 40 years, when Congress wrote ambiguous laws, agencies had the final say on what those laws meant. The Environmental Protection Agency could define clean air. The Securities and Exchange Commission could interpret market rules. The Food and Drug Administration could decide what counted as safe. Courts stayed back. They deferred. That deference is now gone. This matters because it's not about one policy or one administration. It's about where interpretive authority lives in the American system. Who gets to say what a statute means when Congress leaves room for interpretation? For 4 decades, the answer was federal agencies. Now, that answer has fundamentally changed. Supporters of the ruling argue this restores judicial independence and forces Congress to legislate more clearly. Critics warn it strips expertise from regulatory decisions and shifts enormous power to unelected judges. But the deeper question isn't about who's right, it's about what this does to the structure itself. By the end of this analysis, you'll understand 3 things: what the court actually decided, who gained institutional leverage from this shift, and what this changes about how federal power operates going forward. The case that overturned Chevron deference centered on a fishing industry challenge to federal regulations. But the specific facts of the dispute matter less than the doctrine the court chose to eliminate. The Chevron doctrine, established in 1984, held that when a statute is ambiguous, courts should defer to the agency's reasonable interpretation. This gave agencies wide latitude to fill in the details Congress left undefined. The court's majority concluded that this deference violated the judicial duty to say what the law is. Judges, not agency officials, must resolve statutory ambiguity. The ruling doesn't eliminate agencies' ability to make regulations, but it removes their interpretive shield. Every major regulation can now be challenged in court on the basis that a judge disagrees with the agency's reading of the statute. This is where the deeper shift begins. The immediate effect is on agency rulemaking. When the EPA drafts emissions standards, it interprets statutory phrases like best available technology or reasonable cost. Under Chevron, courts gave the EPA deference if its interpretation was reasonable, even if the judge might have read the statute differently. Without Chevron, a judge can simply substitute their own interpretation. The agency's technical expertise no longer carries presumptive weight. The same applies to the SEC interpreting securities law, the Department of Labor defining employee rights, or the FDA establishing drug approval standards. Each interpretation is now subject to independent judicial review without deference to agency judgment. The structural movement here is clear. Authority moves from executive agencies toward the federal judiciary. This represents a contraction of administrative power and an expansion of judicial influence over policy implementation. From an institutional perspective, this creates 3 interlocking dynamics. First, it increases litigation. Every significant regulation becomes more vulnerable to court challenge because judges are now free to impose their own statutory interpretation. Companies, advocacy groups, and states gain leverage to contest rules they oppose, knowing courts will review agency decisions without deference. Second, it changes how agencies draft regulations. Agencies must now anticipate how judges might interpret ambiguous statutory language and craft rules defensively. This may lead to more conservative rulemaking, as agencies avoid interpretations that push statutory boundaries, even when those interpretations serve legitimate policy goals. Third, it shifts pressure to Congress. When statutes are ambiguous, courts will now decide what they mean. If Congress wants specific outcomes, it must write detailed statutes that leave less room for interpretation. But Congress often writes ambiguous laws precisely because reaching consensus on details is difficult. The Chevron doctrine allowed agencies to fill those gaps. Without it, ambiguity creates legal uncertainty and judicial control. What matters long-term is not just the immediate impact on current regulations. It's how this ruling repositions the 3 branches relative to each other. The judiciary gains authority to shape policy through statutory interpretation. The executive branch loses a tool for flexible policy implementation. And Congress faces new pressure to legislate with precision it often cannot achieve. From a constitutional standpoint, this may be more significant than it appears. The court's reasoning rests on separation of powers principles. Judges must judge, agencies must execute. But in practice, modern government depends on agencies interpreting complex statutes across technical domains: environmental science, financial markets, pharmaceutical safety, workplace standards. Agencies develop expertise courts cannot match. Chevron deference acknowledged this by giving agencies interpretive authority within their domains. The new framework assumes judges can competently interpret statutes across all these technical fields without deferring to expert judgment. Whether this assumption holds will determine how effectively the federal government can regulate in specialized areas. Consider climate policy. Congress has not passed comprehensive climate legislation. The EPA's authority to regulate greenhouse gases rests on interpreting decades-old statutes like the Clean Air Act. Under Chevron, courts deferred to EPA's scientific judgment about what constitutes an air pollutant and what regulations are appropriate. Without Chevron, judges decide these questions independently, applying their own understanding of chemistry, atmospheric science, and engineering. The same pattern extends across regulatory domains. Financial stability rules depend on interpreting market dynamics. Drug approval standards require pharmacological expertise. Workplace safety regulations involve engineering and health science. In each area, judges now have final interpretive authority without deference to agency specialization. This doesn't mean agencies become powerless. They still write regulations, they still enforce laws, but their interpretive judgments no longer carry presumptive weight. A district court judge in Texas can override EPA scientists on what constitutes pollution. A federal judge in Louisiana can substitute their interpretation of securities law for the SEC's judgment. The key structural movement is from diffused administrative expertise toward centralized judicial interpretation. This may slow regulatory adaptation and increase the importance of judicial selection, since judges now decide policy questions previously resolved by agencies. If this precedent holds, future administrations may use it differently. A Democratic administration might find its environmental and labor regulations struck down by conservative judges who interpret statutes narrowly. A Republican administration might see its deregulatory efforts blocked by liberal judges who read statutes to require more protection. The political valence shifts depending on who controls the courts and who controls the agencies. But the structural effect remains constant. Whoever wins in court controls policy interpretation. This makes judicial appointments more consequential and litigation more central to regulatory outcomes. It also creates uncertainty, as regulations that survive judicial review under one administration might be reinterpreted by courts under the next. Over the next 2 to 3 years, several developments are likely. First, a wave of litigation challenging existing regulations. Industries and interest groups will test which rules can survive without Chevron deference. Courts will face questions they previously would have deferred to agencies on. Some regulations will be upheld. Others will be struck down or narrowed. The pattern of judicial decisions will reveal how much interpretive authority judges actually exercise in practice. Second, agencies will adjust their approach to rulemaking. They may draft regulations more narrowly, avoiding aggressive interpretations that courts might reject. They may also increase the administrative record supporting their decisions, anticipating judicial scrutiny of their reasoning. The result could be slower, more cautious regulatory activity. Third, Congress may face pressure to legislate more specifically. If ambiguous statutes lead to court challenges and regulatory uncertainty, industries and advocates may push for clearer statutory language. But Congress's ability to draft detailed, technically precise legislation is limited by political constraints and institutional capacity. The gap between what Congress can legislate and what modern regulation requires may widen. The Supreme Court's decision may also influence how agencies defend their regulations in court. Without Chevron deference, agencies must persuade judges that their interpretation is not just reasonable, but correct. This changes the dynamics of regulatory litigation and may advantage parties with resources to hire lawyers who can offer alternative statutory interpretations. Whether agencies can maintain effective regulatory authority under this new framework depends on several factors. Can they draft regulations that survive independent judicial review? Can Congress pass statutes specific enough to constrain judicial discretion? Can courts develop expertise in technical areas where they now have interpretive authority? These questions will shape federal regulation for years. The answers are not yet clear, but the institutional architecture has changed. Authority that resided in agencies for 40 years now resides in courts. That shift will play out differently across policy areas, but the direction is set. From a long-term perspective, this ruling represents one of the most significant redistributions of federal authority in decades. It's not as visible as major legislation or executive orders, but it fundamentally alters how the federal government interprets and implements law. Agencies will still regulate, courts will still review, but the balance has shifted. Judges decide what statutes mean. Agencies must work within those judicial interpretations. Congress faces pressure to legislate with precision it may not be able to achieve. This may not dominate the news cycle, but over time, shifts like this redefine how power actually moves in America. The Chevron doctrine ended quietly, but the institutional consequences will echo through federal regulation, administrative law, and the relationship between branches for decades to come. The question is no longer whether agencies get deference. The question is how government adapts when they don't.